Nix v. Williams, Supreme Court, 1984. Chief Justice Burger delivered the opinion of the court. We granted certiorari to consider whether, at Respondent Williams's second murder trial in state court, evidence pertaining to the discovery and condition of the victim's body was properly admitted on the ground that it would ultimately or inevitably have been discovered even if no violation of any constitutional or statutory provision had taken place. 1. Subsection A. On December 24, 1968, 10-year-old Pamela Powers disappeared from a YMCA building in Des Moines, Iowa, where she had accompanied her parents to watch an athletic contest. Shortly after she disappeared, Williams was seen leaving the YMCA carrying a large bundle wrapped in a blanket. A 14-year-old boy who had helped Williams open his car door reported that he had seen 2 legs in it and they were skinny and white. Williams's car was found the next day 160 miles east of Des Moines in Davenport, Iowa. After several items of clothing belonging to the child, some of Williams's clothing, and an army blanket like the one used to wrap the bundle that Williams carried out of the YMCA were found at a rest stop on Interstate 80 near Grinnell between Des Moines and Davenport, a warrant was issued for Williams' arrest. Police surmised that Williams had left Pamela Powers or her body somewhere between Des Moines and the Grinnell rest stop, where some of the young girl's clothing had been found. On December 26, the Iowa Bureau of Criminal Investigation initiated a large-scale search. 200 volunteers divided into teams began the search 20 miles east of Grinnell, covering an area several miles to the north and south of Interstate 80. They moved westward from Poweshiek County, in which Grinnell was located, into Jasper County. Searchers were instructed to check all roads, abandoned farm buildings, ditches, culverts, and any other place in which a body of a small child could be hidden. Meanwhile, Williams surrendered to local police in Davenport, where he was promptly arraigned. Williams contacted a Des Moines attorney who arranged for an attorney in Davenport to meet Williams at the Davenport police station. Des Moines police informed counsel they would pick Williams up in Davenport and return him to Des Moines without questioning him. 2 Des Moines detectives then drove to Davenport, took Williams into custody, and proceeded to drive him back to Des Moines. During the return trip, one of the policemen, Detective Leeming, began a conversation with Williams saying, "I want to give you something to think about while we're traveling down the road. They are predicting several inches of snow for tonight, and I feel that you yourself are the only person that knows where this little girl's body is. And if you get a snow on top of it, you yourself may be unable to find it. And since we will be going right past the area where the body is, on the way into Des Moines, I feel that we could stop and locate the body, and the parents of this little girl should be entitled to a Christian burial for the little girl who was snatched away from them on Christmas Eve and murdered. After a snowstorm, we may not be able to find it at all." Leeming told Williams he knew the body was in the area of Mitchellville, a town they would be passing on the way to Des Moines. He concluded the conversation by saying, "I do not want you to answer me, just think about it." Later, as the police car approached Grinnell, Williams asked Leeming whether the police had found the young girl's shoes. After Leeming replied that he was unsure, Williams directed the police to a point near a service station where he said he had left the shoes. They were not found. As they continued to drive to Des Moines, Williams asked whether the blanket had been found, and then directed the officers to a rest area in Grinnell where he said he had disposed of the blanket. They did not find the blanket. At this point, Leeming and his party were joined by the officers in charge of the search. As they approached Mitchellville, Williams, without any further conversation, agreed to direct the officers to the child's body. The officers directing the search had called off the search at 3 p.m., when they left the Grinnell Police Department to join Leeming and the rest area. At that time, one search team near the Jasper County-Polk County line was only 2.5 miles from where Williams soon guided Leeming and his party to the body. The child's body was found next to a culvert in a ditch beside a gravel road in Polk County, about 2 miles south of Interstate 80, and essentially within the area to be searched. Subsection B, the first trial. In February 1969, Williams was indicted for first-degree murder. Before trial in the Iowa court, his counsel moved to suppress evidence of the body and all related evidence, including the condition of the body as shown by the autopsy. The grounds for the motion was that such evidence was the fruit or product of Williams's statements made during the automobile ride from Davenport to Des Moines and prompted by Leeming's statements. The motion to suppress was denied. The jury found Williams guilty of first-degree murder. The judgment of conviction was affirmed by the Iowa Supreme Court. Williams then sought release on habeas corpus in the United States District Court for the Southern District of Iowa. That court concluded that the evidence in question had been wrongly admitted at Williams's trial. A divided panel of the Court of Appeals for the Eighth Circuit agreed. We granted certiorari, and a divided court affirmed, holding that Detective Leeming had obtained incriminating statements from Williams by what was viewed as interrogation in violation of his right to counsel. Second trial. At Williams' second trial in 1977 in the Iowa court, the prosecution did not offer Williams' statements into evidence, nor did it seek to show that Williams had directed the police to the child's body. However, evidence of the condition of her body as it was found, articles and photographs of her clothing, and the results of post-mortem medical and chemical tests on the body were admitted. The trial court concluded that the state had proved by a preponderance of the evidence that, if the search had not been suspended and Williams had not led the police to the victim, her body would have been discovered within a short time, in essentially the same condition as it was actually found. The trial court also ruled that if the police had not located the body, the search clearly would have been taken up again where it left off, given the extreme circumstances of this case, and the body would have been found in short order. In finding that the body would have been discovered in essentially the same condition as it was actually found, the court noted that freezing temperatures had prevailed and tissue deterioration would have been suspended. The challenged evidence was admitted, and the jury again found Williams guilty of first-degree murder. He was sentenced to life in prison. 2. Subsection A. The Iowa Supreme Court correctly stated that the vast majority of all courts, both state and federal, recognize an inevitable discovery exception to the exclusionary rule. We are now urged to adopt and apply the so-called ultimate or inevitable discovery exception to the exclusionary rule. Williams contends that evidence of the body's location and condition is fruit of the poisonous tree, i.e., the fruit of a product of Detective Leeming's plea to help the children's parents give her a Christian burial, which this court has already held equated to interrogation. He contends that admitting the challenged evidence violated the Sixth Amendment, whether it would have been inevitably discovered or not. Williams also contends that if the inevitable discovery doctrine is constitutionally permissible, it must include a threshold showing of police good faith. Subsection B. The doctrine requiring courts to suppress evidence as the tainted fruit of unlawful government conduct has its genesis in Silverthorne Lumber Co., the United States, in 1920. There, the court held that the exclusionary rule applies not only to the illegally obtained evidence itself, but also to other incriminating evidence derived from the primary evidence. The core rationale consistently advanced by this court for extending the exclusionary rule to evidence that is the fruit of unlawful police conduct has been that this admittedly drastic and socially costly course is needed to deter police from violations of constitutional and statutory protections. This court has accepted the argument that the way to ensure such protections is to exclude evidence seized as a result of such violations, notwithstanding the high social cost of letting persons obviously guilty go unpunished for their crimes. On this rationale, the prosecution is not to be put in a better position than it would have been if no legality had transpired. By contrast, the derivative evidence analysis ensures that the prosecution is not put in worse position simply because of some earlier police error or misconduct. The independent source doctrine allows admission of evidence that has been discovered by means wholly independent of any constitutional violation. That doctrine, although closely related to the inevitable discovery doctrine, does not apply here. Williams' statements to Leeming indeed led police to the child's body, but that is not the whole story. The independent source doctrine teaches us that the interest of society in deterring unlawful police conduct and the public interest in having juries receive all probative evidence of a crime are properly balanced by putting the police in the same, not a worse, position than they would have been in if no police error or misconduct had occurred. When the challenged evidence has an independent source, exclusion of such evidence would put the police in a worse position than they would have been in absent any error or violation. There is a functional similarity between these two doctrines in that exclusion of evidence that would inevitably have been discovered would also put the government in a worse position, because the police would have obtained that evidence if no misconduct had taken place. Thus, while the independent source exception would not justify admission of evidence in this case, its rationale is wholly consistent with and justifies our adoption of the ultimate or inevitable discovery exception to the exclusionary rule. If the prosecution can establish by a preponderance of the evidence that the information ultimately or inevitably would have been discovered by lawful means, here the volunteer's search, then the deterrence rationale has so little basis that the evidence should be received. Anything less would reject logic, experience, and common sense. The requirement that the prosecution must prove the absence of bad faith imposed here by the Court of Appeals would place courts in the position of withholding from juries relevant and undoubted truth that would have been available to police absent any unlawful police activity. Of course, that view would put the police in a worse position than they would have been in if no unlawful conduct had transpired. And, of equal importance, it wholly fails to take into account the enormous societal cost of excluding truth in the search for truth in the administration of justice. Nothing in this court's prior holdings supports any such formalistic, pointless, and punitive approach. The Court of Appeals concluded, without analysis, that if an absence of bad faith requirement were not imposed, the temptation to risk deliberate violations of the Sixth Amendment would be too great, and the deterrent effect of the exclusionary rule reduced too far. We reject that view. A police officer who is faced with the opportunity to obtain evidence illegally will rarely, if ever, be in a position to calculate whether the evidence sought would inevitably be discovered. On the other hand, when an officer is aware that the evidence will inevitably be discovered, he will try to avoid engaging in any questionable practice. In that situation, there will be little to gain from taking any dubious shortcuts to obtain the evidence. Significant disincentives to obtain evidence illegally, including the possibility of departmental discipline and civil liability, also lessen the likelihood that the ultimate or inevitable discovery exception will promote police misconduct. In these circumstances, the societal costs of the exclusionary rule far outweigh any possible benefits to deterrence that a good faith requirement might produce. The Court of Appeals did not find it necessary to consider whether the record fairly supported the finding that the volunteer search party would ultimately or inevitably have discovered the victim's body. However, 3 courts independently reviewing the evidence have found that the body of the child inevitably would have been found by the searchers.